Welcome to The Verdict, a podcast by the Carlson law firm. And in this series, we go all about car collisions, the injuries that happen because of them, and the topics that surround them. I'm your host, Jeffrey Hinkson, and in this episode, we're going all about the Texas Tort Claims Act and the Federal Tort Claims Act. And in this episode, I'm once again joined by Mike Erskine and Tim Roehrs. Thank you for being on again. And if people haven't seen the other episodes, which I highly recommend you do, can you explain, introduce yourselves, Tim?
Yeah. So my name is Tim Roehrs. I'm an attorney here at the Carlson Law Firm. I've been working in personal injury law and mass tort law. Been working here the last 5 or 6 years in that area. Happy to be here. Appreciate it.
Thanks for being on. Mike?
Mike Erskine. I've been a licensed attorney in Texas since 2002, and I've taken cases all the way from federal court, state district and county courts, all the way to small claims when I've been trying to help people out on things like that too. So it's been an interesting career so far.
Always an adventure.
Yeah, thanks for being on with And this episode, like I mentioned, going over Texas Tort Claims Act and Federal Tort Claims Act. I wanted to go over this because I feel like in the grand scheme of things, like not a lot of people of the general population will know what this is about. And I wanted to give them a brief explainer and introduction of what it is. And in this one, it's going to be more of a general overview. And then we'll have another episode that goes more deeper in depth of certain situations that happen with this topic. So I wanted to kick it off with a question for you, Mike. And it's a question I figured a lot of people would have, and that is, can I sue the government for personal injury?
The short answer is yes, but it's a lot more complicated than that. The short answer is yes, you can for many things, but not for everything. The government's a special entity. It's a special thing, so it has special rules that apply for it. So there are things you can sue them for, and there are things that you can't.
Okay, and following that one, I also want to know, because there's this thing like governments, we hear about it because of like TV shows and movies, they're quote unquote untouchable. And I wanted to ask the question, what is sovereign immunity and where does it come from? Tim, can you explain that?
That's a great question, especially since you're talking to two history majors. It's fun, so the idea, this is different than maybe what you've seen, the diplomatic immunity. That's not that. This is a little different. Sovereign immunity is the idea or concept that you can't. The idea, actually formed in common law years and years ago, Magna Carta and all that. But it's the king can do no wrong. That was the concept, the underlying concept. And it's the idea that you can't bring a legal action against your king, and that was translated into American common law, where we don't want this is the policy idea behind it. We don't want our court systems bogged down where individuals are continually suing the government and can bring them into court over all kinds of actions. And so, that's kind of your general rule to start with. Is the idea that you can't, if it's a governmental entity, and there's a lot of rules about it, there's very complex issues, but basically you can't sue them unless, right? So the general rule is we can't sue them unless certain things are hit. And so that's what sovereign immunity is. And Mike, you want to give some more historical background? I know we got he's a history guy too, so I didn't touch on it completely, but we can go into 1215 and then Magna Carta and how common law versus statutory law. We could really get into this stuff and know that.
As Tim well knows, I have a huge amount of interest in that stuff, you know, both legal history and just history in general. So if you get me started on that, we're going to be here hours and hours and hours. And I think most of the people listening are going to fall asleep out of boredom. No, I mean, Tim nailed it. It's, you know, essentially sovereign immunity, the concept is you don't get to sue the government unless they give you permission to do so. I mean, that's what it boils down to, is you cannot sue the government except for the things that they've said you can sue us for. And just since we're talking about it, I kind of want to point out maybe something that a lot of folks probably get a little confused about, is there's a huge difference between a civil rights violation and a lawsuit and kind of what we're talking about today, which is a tort, you know, and what we're talking about is personal injuries. So there's all sorts of things you can sue the government for. Civil rights, you don't have to have permission to go sue the government over a civil rights violation. That's your civil right. You get that no matter what. They can't prevent you from doing that. But that is a whole different animal than kind of what we're talking about, which is kind of more personal injury type of stuff. And there are lots of exceptions to that rule. Just kind of also, you can sue the government on contract issues if you do business with the government, but that's not really what we're going to talk about. So,
and all these things can interrelate too. I mean, like I've seen simultaneously going after civil rights violations as well as, you know, personal injury type claims. So these things can interrelate. Now that doesn't happen often for logistical reasons with the cases, but they interrelate, right? So yeah, that's what Mike's referring to. If anybody wants to Google more on it or go research it more, it's the 1983 action. You can go figure out what's going on with that. But that's, yeah, civil rights violations is a whole other animal.
Yeah. And so I wanted to get, I guess, to the meat of the episode or the topic, and that is, if I'm just learning about Texas Tort Claim Act, I'm just hearing about it for the first time, what is it? What is it exactly, Mike?
Well, yeah, just kind of talking. So the Texas Tort Claim Act, it does several different things, but probably the most important is just kind of like we talked about before, is you can only sue the government for what they give you permission to sue them for. That's where you go find what you can sue them for. You know, it's a statute, it's a Texas state statute, and it basically lists out, these are the type of things that you're allowed to sue government entities for. Now it also, the Texas Tort Claim Act puts a limit of liability. There's not, even though the government's pretty big and you think that with all the tax dollars they bring in that they'd be pretty well to do, is there is an upper limit of what you can recover from the government under the Texas Tort Claims Act. So it's kind of the two main things it does is, these are the type of things that you're allowed to sue us for, and this is what you're limited to when you do sue us.
Okay, and is there like one or two examples? Because I know I said we were going to go in depth in another episode, but is there a brief couple of examples you can give us that fall under that?
Sure. Tim?
Yeah. I mean, one of the examples that you can do underneath the Texas Tort Claims Act is the use of a motor vehicle. And that's a lot what we deal with in our business, is when you know, a governmental entity is operating a motor vehicle. Now there's particulars, not just, hey, I'm using a vehicle, that's we're good to go. It's a lengthy statute with plenty of exceptions. Two exceptions were wrapped up again and again and again. There's plenty of loopholes throughout it. But one of those is involving motor vehicles. So if the government employee is out operating a vehicle, they act negligently, they hit somebody in it, that's something that would potentially fall within the statute. And I think that's not where a contract, Mike, is that where the contract actions are as well, that you can bring a contract, or is that separate? I can't remember.
It's well, that's the headache with any lawsuit involving the government, is you don't necessarily find everything you want in one place.
Yeah.
You find a lot of it in Texas Tort Claims Act.
Yeah.
But then you'll also find some of it in other statutes, in other sections, and then you have to go look at, you know, there's there's all sorts of crazy things where you actually have to go dig up old case law. And when I say old, I'm talking decades and decades old case law, where they go down and in one case they say, well, yeah, this is something that falls within the statute. And then something you think is like, well, my case is similar to that. But then you find out, wait, no, there's another case that says, no, it's not similar enough and it doesn't fall in the statute. It's kind of, I mean, honestly, the Texas Tort Claims Act is enormously, it's both, it is frustratingly both straightforward in its language, but unnecessarily complex in its application.
Yeah, that's probably the best way to say it right there, is that, yeah, if you're using the motor vehicle, good to go, but it's not that at all. In application, it varies widely. So there's different types it can be involved with, but that's the more common one that I interact with, is the use of a motor vehicle.
Oh wow, yeah. And because I noticed y'all said like you have to go back to older cases and find out what happened. And the thing I wanted to bring up was what is the process like when dealing with a case that falls under the Texas Tort Claims Act? Like, is it similar, or is there more to it than that? Tim?
Yeah, I mean, there's a lot to it. When you're saying you're going to take on, you're going to take Uncle Sam on, or in this case, we're taking on the state of Texas, because when Texas Tort Claims Act, we're not talking about federal claims, we're talking about ones in the state court. Yeah, we'll leave it with that. There's again, this area is highly nuanced. And so take everything we say with a grain of salt. There's quite a bit to it. But when we get a case that comes in, you really have to think about what you want to do with it. The first thing is you want to always go back to the actual statute and make sure it falls within the language there. But then you're going to need to go and dive into the case law and how those sections have been applied, because that's where you really get into the differences in application. So, for instance, you'll probably dive into this more on a later episode, but if you have a police car that has run into somebody, it will matter if those lights are on, if the sirens are on, if they're responding to an emergency situation. All these factors come into play, and there's different allowances within the statute for those different fact patterns. So if a police officer hits you without the lights on, is just driving around generally, and for whatever reason runs a stoplight, well, that's a little bit easier and more straightforward. But then when it starts getting to emergency situations, when they're chasing somebody down, when they hear a call and they're trying to respond to it, it matters what call they're responding to. It matters, what they did, were they going through an intersection, where they were, because they're allowed certain things to do under Texas law in emergency situations. Is it really an emergency situation? It's litigated out. So there's all these little nuances underneath. And so when we get a case in, you have to be like, okay, we got a person in motor vehicle. What other factors are at play here? And that's where you go, one, to the statute to make sure we fit under the general rule itself. Because if we don't fit under the general rule, it's easy to say, nah, we're not going to be able to do anything here. Because if it doesn't fit within the statute at all on first blush, then it's going to be tough to find anything. And then after that, you have to figure out what exceptions apply and go do your research on this. Because the one thing that you can expect in a case against government underneath the TTCA is that you will be challenged on whether or not it fits under those exceptions or whether it fits underneath the statute. You will be challenged on that. There's a few guarantees I can make within the practice of law. I can almost guarantee this one, that you will receive a challenge on these issues 100% of the time. I would probably guarantee that one. That's about one of the few things I would guarantee.
Well, here's another almost guarantee on that. I can almost guarantee that you're going to be challenged on providing notice to the government.
Yeah, of course.
Which is a huge thing under the Texas Tort Claims Act. Is you are required to give proper notice. You have to tell the government I'm thinking about suing you. And you think it's like, okay, well, I was, a school bus, a police car, government employee who's on the job hits me with their car. Let's, just make it easy. Let's say it's a car crash. And you think it's like, okay, well, I call the government and I say, hey, your guy hit me, and what are you going to do about it? That's insufficient notice. That doesn't count. So you go, okay, well, I'll send a letter. Well, if the content of the letter doesn't strictly cover what the statute requires, that's insufficient notice. It happens, you wait a few weeks, maybe you wait 30 days, 45 days, 60 days, I don't know. And then you're like, you know what? This is more serious than I thought it was. I'm going to send my proper letter that has all the information the statute says I have to it, and I'm going to send it to the government entity. Well, there's a chance that you missed the notice period. Because here's the crazy thing is, the statute doesn't tell you what the notice period is. The government entity gets to decide. Okay,
Oh, wow.
and it can be anywhere from a few weeks to 30 days to 3 months, 6 months. It's all over the place. So you have to know the specific government entity. You have to know the notice period. And that's strictly enforced. If you miss the notice period, or your notice is insufficient within that notice period, the case is over.
Oh,
It's like a little mini statute of limitations. Is if you miss that notice or it's improper, the case is done, and there's really no exception. There might be a few, but there's really, practically speaking, there's no exceptions to it.
so technically, like, so say something does happen, like I'm driving down the street, and then so a government entity hits me. So what I'm understanding is that I have to send a formal notice within the time range before the deadline, essentially, and the deadline depends on. See, this is where I'm sort of confused. Is a deadline depending on the type of government entity, or is it depending on the government itself? Is like, how do they determine what is the time limit on where I can send a formal notice?
I love it. You said you're confused. Well, Joe, here's the thing. I am too. And I've been confused for almost the last 20 years about how they figure this stuff out. The answer is it depends on what government entity you're going after. Especially when you're talking about municipalities, cities, that stuff is all over the place. It's all over the place. And, like I said, I've seen typically really small rural communities where it's a couple weeks to 30 days. Typically bigger cities, you're probably more like the 3 to 6 month range. But it's not written down. It's not in one centralized place. You got to dig to find it, or you just have to know because you've done the cases before. So, it's, I agree with you. I'm confused about it too. It drives me crazy every time, anytime I have a case where there's a government entity involved, one of the very first things I do is dig in, and we find out is, okay, what is the exact, even if I think I know it, I go and quadruple, quintuple, however many times you have to check that, is you go check that. Even if you're confident that you know what it is, because it's so critical. The courts have no mercy on you. If you miss it, you miss it.
Oh.
And doing cases underneath the TTCA, it's almost like you're looking over your shoulder, hurling, wait for it to come bash you in the back of the head. So that's kind of the way, that's the way I feel when I'm doing a TTCA case. I'm looking around, rechecking, checking again, making sure I'm doing the right things, reading up on the case law. It is definitely the type of litigation that is highly intensive as far as the hurdles that make you jump over and things you jump through and brick walls you run into in the field.
And Tim, I wanted to ask you a follow-up question, because in this conversation, we're talking about, it can be confusing. There's time limits. There's a hard deadline where it's basically impossible if you miss a deadline to try again. Why do you think in your opinion, why do you think it's so nuanced? Why do you think the government makes it so difficult for people to approach these and file these cases?
So that's an interesting question. There's a lot of, I feel like there's a few attorneys I know that would love to get on a soapbox about this stuff, of why the legislature and the courts end up doing what they do. So there's a couple different actors at play here. So first is to understand, so we have the TTCA itself, the actual written language is from the legislature, right? So Texas legislature wrote this statute, and involved with writing statutes, there's lobbyists, there's people that get involved with the writing of those statutes and have different interests. And you can understand why the government may pass a statute that protects the government from lawsuits, right? It makes sense why governmental entities are saying, hey, I don't want to be sued. Why did I pass a legislation like that? That's actually a pretty easy thing to determine. The courts are who determine the application of the law, right? So they're going to be coming in and saying, okay, we have this fact pattern before us. How does this statute, the Texas Tort Claims Act, how does this apply to this situation? And so they're the ones who are going to begin with application. And depending on the makeups of your courts and your judges involved, different judges and who you elected into those judge positions is important, because those judges are going to make the call on these types of cases and decide how it should be applied. And so, in Texas, there is, I would say, our courts are lean more towards protecting the government. I think I'm pretty safe to say that. That's probably the nicest thing I can say that, but that's what they do. They like to protect the government, and beside the reasons why, there could be multiple reasons why, but I think generally the thing to understand is that if cases are coming down the pipeline in front of the courts, because, well, maybe we need to talk, and maybe when you ask a follow-up question, and maybe Mike can address it, about kind of what happens in TTCA, how it's challenged and how it moves up the food chain. Because that actually kind of applies to this, because the cases go up, typically these issues are resolved up to Court of Appeals and the Texas Supreme Court, because these issues get challenged early. So you may want to ask, and Mike, you might want to address some of that process with the plea jurisdiction, because that actually changes the way it's applied.
Yeah, well, so I mean, it's kind of the question being, why is it so hard, or why do they make it so hard to go after the government? I guess to a certain extent is, we could go and talk for hours on the historical background of what brought that around, but as we're sitting here is, practically speaking, why is it so difficult? Because it is. The law is just very favorable to the government. It has, again, limits on the liability for, even if you have the best case in the world, you meet all your deadlines, you give proper notice, there's an absolute upper limit on what you can do with it. And it's, for the government, 250, for most government, $250,000. That's the most money in the world that you can get under the Texas Tort Claims Act. Doesn't matter if you have the best case, it's worth millions and millions of dollars. 250 is all you're ever going to see, unless you're a county entity, and then it's $100,000. Which, if you went to just most people on the street and said, hey, do you want $100,000 or $250,000? They go, wow, that's a lot of money. Yeah, I'd love to have that. But in the context of litigation, and typically when people are severely injured, that's next to nothing. That's next to nothing. So, the government has a couple of different attitudes. And again, I'm not necessarily saying it's wrong. I mean, if I had the law in my favor and I had statutory caps that limited the liability, I'd probably do the same thing. It's a good decision if you're looking at it that way. But the government looks at it as the worst day I can ever have at court is I might have to pay $250,000. And I know that for the plaintiff to get there, he's going to have to file a lawsuit. I have an enormous number of statutory and case law things in my favor, so I'm going to be able to fight him every step of the way. And there's a decent chance that I can get them on something, you know?
Yeah.
And by the time they get a verdict, they're going to have spent so much time, and I'm going to make them spend so much money doing it that even if they win, it's one of these hollow victories. It's like, congratulations, you got me. Here's your $250,000, or if it's counting $100,000, minus the time, the enormous amount of expenses they're going to force you to pay. Oh, and by the way, you have to pay back your doctors. Oh, and your wage loss, which doesn't really do much for you because you're just repaying basically lost money. Hey, at the end of the day, lawyers want to get paid too. You know, it's a job for us. We want to get paid too. So the government looks at this stuff, and it's a very careful calculation. Is we can just, you know, we're just going to make you spend more time and money than it will ever be worth to you. So they fight hard on it. And a lot of my clients will say, it's like, well, don't they have to spend the same time and money? It's like, not really. You know, it's kind of those things. Is everyone's heard the phrase "good enough for government work"? Most of the lawyers are city or state attorneys. They're on salary. They get paid regardless of how much or how little they do. And there's lots of things that the government can do substantially less expensive than a private citizen pursuing a lawsuit. There's just cost. There's cost savings built into being the government.
Okay.
Yeah. You have a question, Jeff? I wanted to kind of.
No, Tim, you can go ahead, John.
Okay, appreciate it. No, I was going to say that, you know, in a normal case, so one not involving a government entity, you still have plaintiffs have the burden of proof, right? We have to shoulder that burden on, right? We put on our pack on our back and say we have to prove this up. We got to prove the elements of that cause of action. We got to say this person was negligent, that it caused an injury, and we have to prove all that they breached the duty. We have to make sure we hit all those boxes in order to prove that case, which involves litigating the case out and potentially trying the case in front of the jury, which takes time, takes expenses, and everything involved with that. And in those situations, you may not have to deal with those caps, and so it's worth it. What ends up happening when we involve the TTCA, it's as if we were putting a second or maybe third pack on our back, because we have more things we've got to prove up. And not only do we have to navigate the TTCA, but the government has the opportunity to challenge this stuff multiple times over and at really any point, right? Because they're basically coming in and saying, you don't have jurisdiction to do this. You don't follow the statutes ever. You have no jurisdiction, and they can raise that issue. Well, there's some limitations, but they can kind of raise it at when they want to. And so what'll happen is they'll file this thing called a plea to the jurisdiction, and they'll say, hey, you don't have jurisdiction because you don't follow any of the statute. All right. And then what will happen is you go and it's a big giant pleading. You'll go argue this thing. And hey, guess what? You won it. Congratulations, plaintiff. Guess what happens then? That issue is immediately appealable. They can kick it up to the appellate court level, and you can go re-argue that issue again. Let's say you win it again. Awesome. Great. Good job, plaintiff. You are kicking butt. You're one on the one ground level. You won on the second level. And now guess what? We're kicking it all the way up to the Supreme Court on that issue. And you have to go fight it out in the Supreme Court on the same issue for the jurisdiction. Say, wait a minute, jurisdictionally, they don't have there's no way to bring this case, based on this. And they'll go argue that. And let's even say you win that one. You have won 3 times over on this one issue. And it gets kicked back to the lower level courts. And it's like, okay, now I'm back. I have to go back and get my case put together like a normal case pushing through. Oh no, guess what? The government's coming in and challenging another aspect of their jurisdiction, saying, wait a minute, this other portion of the statute isn't it? And we're back again.
And keep in mind that process, if you go through that whole process where you have a motion, a hearing, you go to an intermediary appellate court and all the way to the Supreme Court, anywhere from 3 to 7 years to do that process.
Oh, wow.
That's how long that process takes. And while that's going on, not much else can happen with the case. Sometimes yes, sometimes no, but you get stalled out on a lot of stuff. Now, granted, that doesn't happen too often, but the potential's there. And I know several government attorneys, and jokingly, but not jokingly, is a lot of times they say, well, if I lose on this, is, we can just appeal it, or we can threaten to appeal it. And a lot of times the court will help them out. They just do. I liked Tim's example of, the way he said it is like, if you compare a government claim with a regular claim, it's like we're putting on extra things in our pack, just because it's so much harder. And it's, an example this is why I was saying that, an example I thought of is, if you get injured on someone's property, like if Tim's over at my house and there's something wrong with my house or my property, and he gets injured, he can sue me. That you can do that under Texas law. He can sue me. And typically what it'd be is like, well, hey, Mike, you knew or should have known about this really abnormally dangerous condition on your property. You didn't warn me about it. You didn't take any steps to fix it. And as a result, I was injured. Perfectly good lawsuit in Texas. Normal thing to do. And it's relative, it's comparatively straightforward. Change two facts on that. Just change two things. Is instead, Tim is at a public park, and that's not private, public park owned by the government, and he gets injured at the public park. Okay, well, now we start adding things into that pack, because the first thing is you have to go and you look at it's like, okay, well, is it a normal abnormally dangerous condition, or is it a special defect, which are some magic words? Because if it's one, it's a lot harder or impossible compared to the other. So that's the first question. Okay, is this just a regular abnormally dangerous condition, or is it a special defect? Next thing you have to do is like the government under those circumstances, it's not new or should have known. Okay, you have to prove they had actual knowledge. You have to prove that someone in authority in the government had actual knowledge of the abnormally dangerous condition. Okay, that is really hard to do. I mean, you literally need a smoking gun type of thing. And I'll tell you, in my career, I've probably only seen it 2 or 3 times where we have like an email from a city maintenance person to a manager or person in authority saying, hey, there's a problem on the property that needs to be immediately fixed because it's really super dangerous. And then it gets ignored, right? That's, like I said, almost 20 years practicing law, I've seen that 2 or 3 times. That's how rare it is. But the pack's not full yet. We have to throw in something more, because how, like when we were talking earlier, we said, well, you can't find it all in one statute. Because it happened at a park, now you have to go look at a different statute that's called the recreational use statute, which means that the hurdle you have to jump over to prove all the other stuff before is substantially higher than just regular negligence. It basically has to be gross negligence, which is a pretty high hurdle to jump. So that's kind of when Tim said that, loading up the pack, that's kind of what popped in my mind. That's a really good example is, government claims are enormously complex. Like I said, is they look on their face, the statute seems straightforward. But the application and the kind of the minutia of all the little rabbit trails you have to run down is just mind-blowingly complex. It's kind of one of those things is, United States of America, you don't have to be a lawyer to avail yourself of the courts. Any citizen, you don't even have to be a citizen. Anyone can go in the United States courts and have a chance to have their voice heard. This is one of those areas of law is you'd have to be pretty crazy to try and do it on your own without a lot of expertise. They're tough claims to do.
Okay. Now, Tim, because we're listening to this, well, at least I'm listening to this with me learning about it essentially for the first time. And I'm listening to it and I'm like, man, this is really, it sounds like all the odds are against me when it comes to these types of cases. And let's say I have one and I'm thinking, man, should I even try to pursue anything? And I want to pose a question to you. Why should people, like, even with the seemingly odds against them, why should they at least try to pursue these cases, pursue their case if it happens to them?
Yeah, I mean, I think that it's, for a couple of reasons, it's a good idea to go and talk to an attorney at the very least, because one, they're going to be able to tell you what's going to be involved going after it. And the good news is that when you actually can fit with underneath the TTCA and everything is streamlined out, there is an opportunity that the government will come in and offer something and see if you can get it resolved. Because, you know, they're pretty good at their statutes. The defense attorney, they know, like, they have a lot of protections in place and they know how to use them. But when they know that that we have a good case against them, they're more likely to offer you something earlier on. So it's definitely worth. I mean, I have that age-old legal principle that I was taught is no ask-sees, no have-these. It's important legal concept that everybody should know about. You might as well ask. There's always a process involved, but you would never know what they're going to do until you try. And you can have that discussion with your attorney about, you know, what's going to be involved with trying. You know, if it's highly convoluted and the potential payoff may not be worth your time, then maybe it won't be worth it, but you should talk to them about it. Because maybe there isn't going to be many things to overcome. And because each case is so different, every case is presented with a whole host of new issues. So you can't, unless you understand the nuances of this law, you can't come into it saying, this is a bad case, just I can't go after the government. No, that's not what you should be hearing right now. Every case is different and every case is highly involved. But you can look at these things and decide, okay, these are the things that I have to overcome. These are the areas that are going to be challenged. Some of them are easier to overcome, some are harder. And so because each one is so different and each exception, and these are all, again, I think I've used it a couple times in the past few days, it's fact intensive. And especially in TTCA. Because if you have a good fact that there's a Supreme Court case on, like, wait, I might have a little something here. This might be a good idea to pursue this. We have a good chance of winning at the lower level courts, or we have a good chance of convincing somebody for the government to pay out and say before you file it, because we have something good in it. And so unless you know these nuances of what's good and what's bad, you need to go talk to somebody about it. So I would encourage anybody that has a claim against government to go and ask somebody, and maybe ask a couple somebody to see if they think it's worth pursuing. Because you never know. You just never know. There's different fact patterns every single day, and different court cases coming out. So you may have a good area of law that you think is worth pursuing.
Yeah.
Well, and I'd add on, yeah, we've been taking government claims for years successfully. But they are complex. There's a little bit of, no, you shouldn't talk yourself out of at least looking into it. But people do have to understand that they're enormously complex compared to similar claims against private citizens. Something else I throw in there is sometimes what you find out is, yes, the government's involved, but there could be a private contractor.
Good point.
And the same rules don't apply. You know, an excellent example would be, you know, like a road work case. You know, the city is responsible for maintaining roadways, sidewalks, sewage, all that kind of stuff. But they hire an outside contractor to do the work. Under certain circumstances, the city remains in there. They probably have some liability, but they get all the protections of the Texas Tort Claims Act. You might find that the contractor they hired to do the work does not share exactly the same. Sometimes they get pseudo government protections, but a lot of times they don't. And in which case, then you have a very different situation. At that point, it's like, well, why do you even care about going after the government with this really difficult, complex, you know, thing, when there's a different entity who's actually really more primarily responsible that you don't have to, you don't have to deal with the same things. But again, a lot of times you won't know that unless you have someone dig in, and you got to find, you got to find the contracts, you got to find the work agreements, you got to figure out what's going on. That's all stuff you get through open records requests and things like that. So, one other thing is, again, like Tim said, is you don't know until you look at it. You don't know until you look at it. And sometimes what you find out is what you thought was your government claim really isn't a government claim, and you don't want it to be. So, there's that too.
Okay. And the last thing I wanted to touch on about the TTCA is that, because we're in Texas. Texas is a big state, thousands of cities, multiple counties. I want to know, is there any factors that change depending on the county or city that I live in, Tim?
Well, yes, but as far as, let's kind of go back to it like this. So underneath the, whenever you're bringing a personal injury case, there's the underlying suit that you need to have, the normal factors for them. That's not going to change. You're still, someone has caused you harm, they were negligent. Those types of things are going to be involved. When you get into the underneath the TTCA, there's certain provisions you need to hit, and those aren't going to necessarily change based on city and county. There are differences in the caps that are applied, and that's kind of a big difference, I would say, between the different types of entities you're going after. That there's a lower amount for counties. Counties, right? I'm trying to remember. It's been a little bit since I've done the research on this. It's 100,000 for counties, right? Mike, is that right?
For counties, yeah.
Yeah. So there's a lower damage cap against counties, and so that's the big difference, I would say, between the two. But again, you're gonna have to go back and check into individual claims and make sure there's no other hurdles you have to jump over. But the big one is the money at the end of the day. And also every claim has those highly intensive hurdles you have to jump over. So when you have a lower amount at the end of the day, it's kind of like that pack scenario. You're loading up that pack and trying to make this journey. If you survive the journey and at the end of the day, you're left with a very small amount, and it's diminishing returns because you're gonna have to pay a lot of money and a lot of expenses to get there. And so the case against counties are a lot harder because of the cap involved. From just a practical standpoint, because you're going to spend a lot and you're not going to get much at the end of the day compared to maybe another governmental entity. So that's something you really have to think about as you move forward.
Okay. And so we covered Texas Tort Claim Acts, and we're about to get in Federal Tort Claim Acts. But before then, I just want to throw out a quick fact that in 2003, the tort reform went into effect, which limited damages for pain and suffering in most malpractice cases. And before we dive into the FTCA, I wanted to throw out, because there's a phrase that I've heard, pretty sure both of you have heard also, is that there are no frivolous lawsuits. And I wanted to get your guys' opinion on that, starting with Mike.
Well, I'll tell you honestly, the way the term is used currently, I very much disagree with, because what it is, there's people, it's a lightning rod for emotion. And the way it's used is there's people who say any lawsuit is, there's just folks that any lawsuit anyone dares to file is frivolous. So in the sense, the way it's used right now, especially in the media, on the news, by politicians and special interest groups, I just absolutely disagree with it. Because what they're, basically their implication is anyone that dares to file a lawsuit against an entity that I like, it's frivolous. That's how it's being used. Now, if you ask me, is just in the broadest sense of the term, is there such thing as a frivolous lawsuit? Sure. There's no doubt that the court system does get abused to a certain extent. But here's the reality. It's enormously rare. I mean, it's something that's just so rare. The way the term is used and what it actually means is a true frivolous lawsuit that has no basis in law or fact. That's what a frivolous lawsuit is. It's actually an enormously rare event. And our court system is set up to handle those. Our court system is set up to handle, and it actually handles those very, very well. If there is not a basis in the law, or there's no factual basis for a lawsuit, those get handled through motions, and they can get handled relatively quickly and relatively inexpensively. So the answer is, like, is there such thing as a frivolous lawsuit? Sure. There's lawsuits out there that it's just someone has an axe to grind, too much time, and they have enough money to file a lawsuit. I agree, that does happen. Not in the sense that it's used by politicians and special interest groups and people in the media. Overwhelmingly, most lawsuits have a basis in fact. When people say frivolous lawsuits nowadays, what they mean is, I don't agree with you, and I wish you didn't sue me. It's basically, any lawsuit against me is frivolous, but mine are okay. That's how the term is being used nowadays. So there you go. It's kind of a complex answer, but yeah, they do exist. But the way it's being used now is ridiculous. Our court system is well set up to handle those. And the vast, overwhelming majority of lawsuits, they're fair game. That's why we have a court system. Y'all probably heard me say this before, is rather than have people meet at high noon and shoot each other in the streets, is we have courts of law. And that's where we want people to develop, hash out, and settle their disputes. And our court system does work. It's not perfect, but it works pretty dang well. And I'd still take it over any other alternative form of justice in the world today.
Okay. Tim, did you want to add something?
Mike touched on a lot of good points in there, and I'll do my little blurb about the right to trial by jury, which is one of our rights, and it's an important right. And the reason it's so important is that if you look throughout history at the way that governments have abused power, one of the most basic ways in which they abuse power is that they are punishing folks without any due process, right? They are putting them through the ringer, and so there's that element. So the government type coming in and stepping in, and the right to trial by jury is important in the criminal aspect. And the civil aspect is extremely important as well, right? And that's what Mike was talking about, is we have a mechanism to resolve disputes. And that jury trial, it echoes back years and years and years. In first instances, even back to Iceland and Parliament. There's lots of things throughout history. I could get into it. But the main thing is that it's so important because we need a mechanism to resolve disputes. And being able to go in front of a jury of your peers is one of the base rights of the American people. And it's so important to have it. And so I in the sense that should people be allowed to bring lawsuits? Absolutely. Are there people that bring lawsuits that I personally think was probably a bad idea to bring it, and I think that's a waste of time? Yes. Do those lawsuits generally get kicked out appropriately by the courts in the right timing and through the right procedures and motion practice? Yeah. I can tell you that the end results, generally speaking, the end result we get to is I can't really say the right one, because that is a loaded concept. But the idea is that if someone's bringing in a claim that really has no basis in law and fact, it gets dealt with pretty efficiently, with exceptions. But if generally it's going pretty well, is the way I'd say it. So it's good. And I would caution any person that's going and hearing about a lawsuit that's going on to judge it as quickly, saying, well, that's frivolous or not frivolous, when you're not the active party involved in it and you don't know the nuances of the case. There is a lot more involved in these things. As we've just touched on with TTCA type cases, there's a lot involved with lawsuits. And so to sit there and to judge from the outside looking and say, well, that's a frivolous suit. That's stupid. We should never bring it is a little bit premature before you know all the details and the law involved. So be aware that as you're quick to judge and patience for all people. That's just general good life advice I have for you. So.
Okay. Yeah. Okay. So moving on, we just covered the TTCA, Texas Tort Claims Act, and now I wanted to move on to the Federal Tort Claim Act. Now, Mike, I know, because TTCA covers, I'm assuming Texas, just Texas in general, but FTCA, Federal Tort Claim Act, covers a much wider area. What is it exactly, and what are the differences between the two?
Well, they're similar in that the Federal Tort Claims Act and all the other kind of collateral statutes and laws and stuff like that associated with it, it accomplishes the same thing, just for the federal government. So Texas Tort Claim is easy enough. Texas. Okay. So it's limited to the state of Texas and the laws that apply within the state of Texas. Federal Tort Claim Act is similar. It just applies to federal government entities, and that's one of the that's where they're similar. But frankly, the two acts are very, very different in flavor. There's things that are profoundly different if you look at the content of the two acts, and frankly, there's a lot of stuff about the Federal Tort Claims Act that are probably more favorable in a big picture than under the Texas Tort Claim. The Texas Tort Claim Act is arguably a little bit more draconian, and certainly with its limits of liability, is a much harder act to obtain any kind of relief under, mostly because of the liability limits. Now, the federal government, there's kind of similar things. There are hurdles to overcome going after the federal government. And they also have notice requirements, a little bit different than Texas. It's a different type of thing, but you also have to give them notice. You have to do it the right way. The courts aren't forgiving about errors, even if they're minor, and in some cases, even if they're clerical. But of the two is, push comes to shove, I'd probably rather take a Federal Tort Claims Act than a Texas Tort Claims Act for a lot of things.
Okay, Tim, would you have that same sentiment where you would rather go for federal tort rather than the Texas tort? And what would be some of your reasons for that?
Yeah, I mean, I definitely would want to. I agree. I wouldn't want if I'm going to choose a case and I have my pick of the two, it's going to be FTCA. One of the nice things when you're dealing with because what happens is when you file these cases, so if you file an FTCA case and you say, okay, wasn't able to agree with the government on this one, we're going to have to file a lawsuit, and here we go. You're not filing in state court, you're filing in federal court, right? So you're going to be in federal district court. And let's just say that federal judges don't allow as many shenanigans as state court judges may. I had a professor, I think, tell me once that the federal court judges are, like the gods of Olympus on high and descending down cloud to cloud to give us just, rationale. So federal judges they are more efficient, I think, in federal court, and so it helps with the processing of things. And there's just, the statute itself I like it because it makes more conceptual sense to me, like the FTCA does. And I also find that claims under the FTCA, even pre-litigation, they're more likely to give you offers and talk to you and see if they can get something done than under the TTCA. That's just my personal experience, but like when I bring a TTCA type case, they're going to find a way to deny it if they can. They both will, don't get me wrong. But I find more often when I'm bringing a TCA case, I actually have a chance of getting it resolved pre-suit. TTCA, I tell my clients if we're going to be investigating a TTCA case, then I'm going to tell them like, get ready for litigation. It's probably coming. If we get that resolved ahead of time, then I will be very surprised. The FTCA is like, there's a chance, let's take a shot at it. So, I mean, I don't know if you notice much of a difference between those two sentiments, but there is a difference, and a chance of getting it resolved without having to jump through the hurdles is great. If you do get a real number off by the government. So that's some of the reasons I like the FTCA.
Okay. And Mike, because you had mentioned that the dates for filing might be a little bit different from the TTCA. Does it wildly fluctuate like TTCA, or do they have a more quote unquote like stricter policy when it comes to dates where someone can formally file?
Well, it's not so the date. So when you say the dates for filing, that kind of means something different.
Like the deadline, I mean. Like,
yeah, to me, then I think what you mean is as far as the process for providing notice for the government.
Yes.
Yeah. So the federal government, actually, it's much easier. Well, I don't know if it's much easier, but it's much better defined under the federal system. There's actually a form. Shocking. The federal government has a form for you to fill out. I know, no one can believe that, right? It's called the SF-95. It's literally a form that you fill out where you tell the federal government I think I have a claim against you. Here are the basic facts of it. And this is what we want to do with it. And as long as that form is filled out filled out timely and correctly, that's it. You provided them notice. It's actually, in one sense, again, it has to be done correctly. It has to be done correctly. But if you do it correctly, it's actually much easier and a lot less subject to, well, what date do I have to send this by? Is this letter good enough? What more do I have to do? Different material? What material do I have to do? Is this proper notice? Is it sufficient? It's actually much more straightforward. You fill out the form, you file it by the deadline, you're good for step one. So that part of it, at least, is a little less. It's less nerve-wracking on the lawyer end of it, because it's like, I've got a form, I've got a date, and as long as I fill in these blanks on the form, I at least have my claim in. So to that extent, I like that a lot better. It's a lot more straightforward.
Yeah, because honestly, coming from myself who's learning about most of this, all of this, yeah, that sounds way easier than dealing with the Texas Tort Claims Act and what you have to go through with that. And Tim, I want to throw it back to you because there's limits on the TTCA and how much you can make when everything resolves. Is that the same way for the Federal Tort Claims Act, and what is that limit?
So underneath the FTCA, and again, it's been a little bit since I've done an FTCA type case, I'll be honest with you. But my understanding is that no, there's not a damage cap. I might jump in and correct me if I'm wrong, but there's no damage cap, but they can apply damage caps from the state level. So I think there's an interrelationship between the two. Now, with that SF-95 form, you do have to petition for a certain amount, and that can sometimes act as a cap. So you have to be careful about what you fill in on that blank, because you can actually cap yourself, which, that don't do that. So be careful with what you put in there. And so, yeah, I mean, there's certain benefits of going out into the FTCA, but there are, you still have hurdles to overcome. Because they can still apply certain caps from the lower level, or from the state level. And then if I remember correctly, I don't believe you can get punitive damages against the federal government either. So that kind of damage is tossed out. So there's other different, Mike, am I remembering that correctly?
Yeah, well, yes, basically. I mean, that's kind of how that works out. The other kind of primary difference is, under the Federal Tort Claims Act, it limits the amount of attorney fees that are available. It dictates that. So there are things that it's more clear on. And generally speaking, in fact, overwhelmingly, is if you sue the federal government, so you sue them under the Federal Tort Claims Act, you get what lawyers call a bench trial, which means that the judge is both the judge and the jury. You don't get to have a jury of citizens. The judge makes, here's the evidence, makes the rulings, and makes a decision. So that's kind of one of the trade-offs is, under Texas Tort Claims Act, you get to go to a jury. So, your fellow citizens would hear that case eventually. Federal Tort Claims Act is you're probably winding up in front of a judge with no jury.
Okay, that's interesting. Why, is there a reason for the difference why there isn't a jury in the FTCA?
That's how it got run. Because I wish I had a profanity for you, just because that's how it worked out. So.
I guess I could argue that maybe this is law by Tim, has nothing to do with actually researching the issue, the policies behind it. But I can understand if if these, when you're dealing with these types of cases, there is quite a bit of, it's law intensive, right? Because it depends if it falls underneath the statute. So I can understand maybe why they want to do bench trials on some of these issues, because it consolidates that, and you can resolve those issues of law, which are for the judge to decide. So maybe that, but yeah, it just is what it is. That's probably the best answer for you.
Okay. And lastly, Tim, because when I was asking you about the caps for how much someone could possibly make, you had mentioned that it's best not to just fill out a number because you could cap yourself. Is it better to speak with the attorney and find out what's the process behind finding out what the number should be? Because I know every case is different, but in a general sense.
Well, yeah. I mean, filling out that form matters, right? That's the key point to take away. You can't just be like, well, I'm just gonna fill out this form. I'm like, I don't need an attorney for that. I'm gonna send this over. And there are repercussions for the things you put on that form. So be careful about just saying, well, I'm gonna try to fill out this form and see how it goes. Because guess what? Once you fill that form in and send it, it's sent. It's there. And you could end up hurting your case moving forward. I'm not gonna say it's, again, some of this is nuanced, which is why you talk to your attorney about it. But you do need to talk to them about what you put on there. As far as the valuation that you put on there, there's reasons why you want to maybe not put just $1 billion on there and leave that as your cap. There's other reasons for that. You don't want to just put carte blanche across the board there. You can get in some trouble with judges later on that kind of stuff. So don't do that. There's reasons to keep it lower. You might get a better chance of the result. And so you have to have an idea of case valuations. You can actually put a reasonable number on there. And that's why I talk to an attorney. They're going to be able to guide you with what to put on a form. So that way you're not going in there and running blind on these kinds of cases. They're going to give you the idea of what to put on a form, not just in that one, but all the other ones involved too. Because you're filling out, the thing to remember on that SF-95 form, this isn't, like the TTCA, where you do have certain notice requirements in there. But in the SF-95, you're putting a lot more about your case on there, right? You're including issues about your damages. You're including, support for those, and you have, a breakdown of the different types of damages, for the lost wages. Everything is going to be put on that form, and you're making claims for it. So you have to know how to calculate all that stuff. You have to know how to put those different damages on the form. Unless you're familiar with all of that, yeah, you're going to talk to a professional to be able to make sure you include all that stuff on the form. So it matters. The form matters, and there's more to it than just like filling in a few blanks. You have to know why and what you should put in there.
And yeah, Tim's spot on. Part of that is just kind of it's the different approaches between Texas state law and procedure and federal law and federal procedure is Texas is what's known as it's a pleading jurisdiction, which means that you can be pretty, in general, you can be fairly vague. You can't be completely and totally, you have to have some basis. But Texas courts don't require that you have a ton of facts and a ton of supporting information initially for pleadings. Federal courts are much more traditional. And as a result, anything you do in federal courts, including the pre-litigation SF-95s, is there's an expectation that there's going to be more details and more supporting documentation for anything you say and you do in there. So Texas is kind of what they call notice pleading, which is, hey, I've got a claim, here's some real basic information, and let's go do discovery and figure out what this is all about. Federal court is not a notice, pleading. Is they expect is like, okay, no, you have to flesh out and you have to be a little bit more exact and tell us exactly what you're doing and why you think you can do it. So that's kind of one of the primary differences. Is Texas is like, take a swing at it, let's see what happens. Federal court is, no, you better do this right, and we're not going to give you many chances to do it right.
Okay. And lastly, I wanted to ask both of you, is there anything you would like to add regarding TTCA, FTCA, any stories, any types of cases you had to deal with? Mike, you're laughing.
The whole story, I just have tons of stories on that. I don't know. I'll share one story that just because it was near and dear to my heart. Several years ago, it's very sad. It's very tragic. I mean, I was laughing. I was kind of laughing and smiling because, do you have a story that you want to share on that? And absolutely there is. But it's a very tragic story. And what it did is I represented a young teenage boy who had been driving in a truck with his father. And his dad was a trucker. He's a commercial truck driver. And he'd taken his son out. His son is like, you want to ride in the big truck? I was like, hey, I want to ride in the big truck with my dad. And it was his dad day to have him. So I was like, yeah, let's just go take a spin. We'll just go, we'll go drive down the highway in the big tractor part of the tractor, big giant truck. So, hey, this is fun. We're going to do this. And as they're going down the roadway and they're not doing anything wrong, they're just traveling, they're going the speed limit, they're in their lane. And a county employee driving an 18-wheeler with a rig, literally right in front of them, just pulled right in front of them. And the guy had no place to go because he was blocked in by the back end of the county employee's rig. There was traffic to the left of him. So he ended up hitting the guy, flipped the truck, and it was just horrible. It tore the top of the truck off. The father died, and the son was trapped in the seatbelt, basically hanging upside down with his dad dying next to him. I mean, it's just this horrible, heartbreaking thing. And we found out that the county employee that was driving the truck had only had a commercial driver's license less than 30 days. He had never, he'd never gone to a driving school. He'd been trained on the job by other county employees. And yes, he passed the driving test. But the guy he just had this terrible history in his personal vehicle. It's just an irresponsible driver. And this is who they were letting drive an 18-wheeler for the county. All right. So there you go. It's you look at this and normally it would be like, okay, what happened is super clear. The injury, the guy dying, the kid having to see his father, hanging there dead next to him. Horrific. I mean, this is something that you think is super straightforward. But it was a county, and what we talked about before, counties have a limitation of 100. That's the most money you can get from them. 100,000. That's it. Not a penny more. And I kid you not, the insurance adjuster who was, basically representing the county. So the county belonged to one of these municipal leagues where they actually purchase insurance and they have insurance adjusters. The insurance adjuster agreed that no, the liability is clear. I understand that it's a terrible injury, but I'm going to deny the claim because I don't think you're going to spend the money and the time to come after our $100,000. I'm not kidding. That was his basis, is I'm denying it. I'm not going to pay this family for their loss. I'm not going to pay for this kid for having to see his father die next to him, because I think it's going to be too expensive for you for just $100,000. So claim denied, too bad, so sad, goodbye. That's the attitude a lot of these government entities have. It pissed me off pretty badly. So I'm like, you know what? I don't care how much it costs. I don't care how much time it takes. We're going to do this. And eventually, we got it done. And we actually ended up getting more than the $100,000 because of a very unique quirk in the law that has since been changed, so we couldn't do it anymore. But we were actually able to get, more than what the normal cap would be. We were able to basically stack 2 caps on top of each other. You can't do that anymore. The law's changed since then. So, there you go. You find a way to help someone a little extra and they change the law on you. So, but there's an experience that I had. And yeah, they threw up all the roadblocks. They did all the motions that they could. They threatened to appeal things. They threw up every roadblock they could. And it was very time consuming. It was expensive. But in that case, it was absolutely worth it. You can't let anyone get away with an attitude like that. But the government does have to be held to account when they do things wrong. So there you go. There's an experience I had. That was several years ago. And it's kind of one of those things that happens. And that it illustrates both the success you can have through doing Texas tort claim stuff, but also the frustrations involved with it and just the attitudes you run into from government lawyers and government entities.
Yeah, that sounds frustrating, just having to deal with all that. And it's good that there was a good conclusion that you were able to get it resolved. Yeah. Tim, is there anything you would like to add?
Yeah, I mean, it's when dealing with these types of claims, it's unfortunate that we have to have the initial conversation with the client telling them, hey, these are tough claims, especially in those situations like Mike is describing, where it's a really horrific accident, a horrific collision that happened, and they have people that are really, really hurt. In those situations, or even in situations that don't involve motor vehicles, where someone's hurt on government property, there's a lot of hurt victims. The best thing to do coming into these situations is always ask and see if you fit underneath those, underneath the statute, either the FTCA or TTCA. Always ask to see if you fit underneath any of your fact kind of fits under that statute. And then also temper your expectations on these types of claims. Worth it to discuss, worth it to check into, but don't come into a case against the governmental entity saying, I'm about to make big money, this is about to happen, I'm there to pay out all my damages. No, you need to come here with some tempered expectations. And I think that one of the things that Mike said that I really want to encourage people as well, that some of these cases involve entities that are not governmental. Some of these cases, when you come in and you think, oh, just because it involves government, I'm out, I'm done. They don't do that. Do not do that, because there's always a chance somebody else may be involved. And that's one of the things we do. We don't just come in and when you come into my office and say, well, I was involved with the collision with the government entity. Cases involving, someone was being chased, and they were being pursued by a police officer and they were wrecking their vehicle. Well, maybe there's actually a products case here. Maybe this person had defective airbag that didn't go off when they ran into a tree, and you can go after that company for the fact that if they would have had those airbags go off, they would have suffered those maybe really horrible damages. Just because they were, may have been doing something they shouldn't have been doing out there, running from the police officer. There's still an opportunity to say, well, the company should still make cars correctly. They still should make sure that the people that are in these, that's what these are, airbag and safety features are for. So there's other things involved, and you always want to look into those things, because even if it involves government ownership, that's not the end of the story. That's not the end of what we can look into. And that's why I would encourage people to come into these, temper your expectations, but do come in and talk, because you never know. You just never know. Worth it to check into.
Okay, yeah. So, and then they make sure, if something happens, check in with the attorney, see what they can do. Yeah. But yeah, that's it for this episode of The Verdict. Be sure check back with the other episodes. I want to remind everyone watching this one that we will have a follow-up episode on this topic, going deeper into the types of situations when you deal with collisions with different government entities like police cars, EMS, and things of that nature. So be sure to check that one out also. And if you're listening on any podcast platform, be sure to rate us 5 stars. And if you're watching this video on YouTube, be sure to subscribe to our YouTube channel, the Carlson Law Firm. And if you want to go into more detail about the topics presented in today's episode, we'll include links to relevant blogs in the video description. Also, we're on social media, the Carlson Law Firm. You can find us on Facebook, Twitter, Instagram, and LinkedIn. And we also have a Facebook page dedicated to news and updates in Spanish, Carlson Abogados. Lastly, if you're looking for an attorney, our bilingual team is ready to help you out. You can reach us at 800-359-5690. We take calls 24/7, and we have multiple locations, 14 locations in Texas. Go to carlsonattorneys.com to find one near you. Yeah, so thank you, Tim. Thank you, Mike, for joining me again on this episode. And until next time.